But couldn't they have learned about it even previously? Because a lot of these defects or alleged defects with the appointments occurred even before the primary election, and they relied on the same board to certify the results of the primary election and to draw the ballots for the general election and to undertake all these other actions in connection with their duties.
But it was not known that the commission was so flagrantly disregarding its obligations. It was simply not known to the public.
But they could have known.
How would they? Well, yes. I mean, if there had been some reason for them to look into it, they would have done. But there is no duty out there to examine into the credentials or the qualifications of the commission absent some reason to enter into that inquiry. And that inquiry was entered into immediately, the day on which the media report first arrived. And within 1 week, a petition with supporting information, verified information, was put before this court. Secondly, and equally, there is no prejudice. The issue was raised before the inauguration, in time for decision, and the only arguable effect is the inauguration may be postponed. But that is something that the Organic Act of Guam plainly anticipates. There is a specific provision for the governor to continue in office until the successor is duly selected and elected.
But there's also a specific provision that the term of the governor has to commence on the first Monday in January.
Unless there is no duly elected successor, in which case the sitting governor remains until that occurs. Elections and inaugurations are, when necessary, when the law compels, postponed. It happens. It's not a desirable thing. We're not happy to be here with this claim, but it is something this court cannot disregard. The thing I want to emphasize, the thing we want to emphasize, is the relief and the remedy that we are asking for. We're not asking for the election to be done over. We are not.
You can finish your statement.
On this point, if I may. We are not asking for the voters' will to be nullified or ignored. To the contrary, we are asking that all of the votes that were cast be counted fairly, and be counted by a body that is legitimately in place under the law to do that counting and tabulating, to make the decisions that need to be made, and to certify the result when it is properly established. That's not, even if the commission is reappointed in its exact same content, the exact same people are reappointed, even if that were to occur, this is not a nullity, it's not a harmless thing, because respect for the law is never a nullity. It's never futile to insist that the law be followed. And once this court gives its corrective mandate, as it should, then one has to believe that the Guam Election Commission will act legally, as it has not in the past, and will act to effectuate the true will of the elected of the people of Guam. Thank you.
Thank you. So who's arguing first, Mr. Cabot?
That's correct. Please support the Chief Justice Forrest, Justice Merriman, Justice Demapon. Good morning. If this
Mr.
court,
Cabot, is it true that the record reflects there are no valid resolutions passed by the party appointing their delegate to, or their nominee to the commission?
no, that's not true, Your Honor. In fact, the record is not clear, as we've argued in our brief. They have brought up incomplete, legally incompetent evidence before this court. There's insufficient evidence before this court in order to establish that fact. The race.
Have you provided contradictory evidence that suggests that the appointments were made by in pursuant to a resolution?
We don't know, Your Honor. We don't have complete information ourselves. They raised the argument that because it's not in the GC files, therefore it doesn't exist. Their assumption is that it must be in the GC files, and that's their biggest flaw. And that makes their entire argument false. These resolutions, as the statute clearly tells us, does not go to the GEC. Once in a while they CC copies to the GEC, but these go to the governor. So it's not correct that because it's not in the GEC files, therefore it doesn't exist. They have brought before this court 2006 resolutions that seem to exist, but they're not in the GEC files. So even by the evidence that they're bringing up before this court, argument does not hold water. These are also resolutions that are coming from the parties, which in effect are non-governmental entities. They're private associations that are registered with revenue tax, registered with the GEC, but basically are not part of government. And we find it very hard to believe that the mistakes of the party, a private association, are enough to stop a Guam election, enough to stop the operation of government, enough to nullify an election. So,
Well, they assert that they're not directly contesting the vote. The vote will remain as is undertaken.
that's
What
correct.
they want is a composition of an election commission in compliance with the law to proceed with the post-election decisions.
Then what's
So
the-
how is that necessarily changing the election?
It doesn't affect the outcome of the election, but the net effect, Your Honor, is that it will nullify the entire result of the general election. Not only the general election, but also the primary election. Because as Chief Justice has pointed out, it was the action of the board that certified the winners of the primary election that advanced onto the general election. It is not only calling into question the 2010 election, it is calling into question, cast a cloud over all of the elections that have been conducted over the last 10 years. We don't know if in fact these party resolutions exist or not. We've advanced an argument in our briefs that they have not put forward credible and legally competent evidence to establish that fact, and therefore that argument should fail, Your Honor. In effect, what we're talking about and what we're complaining about is the November 6th certification. The November 6th, 2010 certification in which 6 members of the commission declared the winners of the gubernatorial election after the November 6th recount and certified the results of the election. The vote was unanimous, where we had 3 Democrats, 2 Republicans, and 1 independent member all vote unanimously to certify the results of the governor's race. Even if we were to throw out the 2 questionable votes from the independent member Robert Cruz and Republican member Joseph Mesa, whose de jure terms clearly have expired, we would still have 4 votes. 3 from the Democratic Party, 1 from Republican member Martha Ruth.
But that presumes that Ms. Ruth's term didn't commence until she took her oath of office.
That's correct, Your Honor. And that is the argument that we're making before this court. And the reason we're making that argument is because none other than the Organic Act requires that all government officials be administered the oath before commencing office. I don't know of a single office for public office or a member of a board that is not administered an oath before commencing office. It's ludicrous for them to argue that it's not required of the GEC to be administered an oath before we assume the office. So when we get the appointment letter from the governor, we reconcile that and we read it in harmony with what we believe is required under the Organic Act.
What if she exercised duties before taking the oath of office?
Then we believe that those actions may possibly be invalid, unless she was still within the term of her earlier appointment. And we believe that Martha Ruth on November 6th, and at the time of the signing of the certificates of election, clearly was a validly sitting member of the GEC. She was appointed pursuant to an appointment letter from the governor on October 29, 2010. She wasn't sworn in until October 29 of 2008. She wasn't sworn in until January 21 of 2009, which means that Martha Ruth's term would not expire until January 21 of 2011.
The statute isn't specific as to when the term commences, though, right?
That is correct, Your Honor. It says 2 years. But we read it in harmony again with what we believe is a requirement of the Organic Act.
What about the governor's letter that specifically states that her term will start today?
That's not the way we read it, with all due respect, Your Honor. We read the governor's letter, again, reconciling it in harmony with the requirements of the Organic Act. You look at the appointment letter for Mr. Joe Mesa, and in that particular appointment letter, the governor, Camacho, knows how to set a exact, specific deadline or end of a term. You look at Martha Ruth's appointment letter, it says, I appoint you effective today for a period of 2 years. Read in harmony with the requirements of the Organic Act, we interpret that appointment letter as saying, you can start today, but definitely you have to fulfill the requirements of the Organic Act you have to be administered the oath. So I still think that the appointment letter is consistent with the argument of the GEC, Your Honor. Martha Root's term did not commence until she took the oath. Her 2 years did not expire until January 21, 2011. On November 6, the date of the certification, she was a validly sitting member of the GEC. So if we take the 3 Democrats that clearly are within their 2-year de jure term, you take Martha Root, who clearly is within her 2-year de jure term, the 3 Democrats and Martha Root are more than enough under the election code to certify the results of the election, since the election code only requires 4 votes. But we're not only saying that the GEC had 4 votes, we're saying they had 6 votes. The 4 de jure members and the 2 votes from the de facto members, that being the independent member Robert Cruz and the Republican member Joseph Mason. In order for the petitioners to prevail, they have to prove to this court why the de facto officer doctrine doesn't apply. We believe that it should apply. All of the rationale that has been used and relied upon in countless courts throughout the nation clearly applies to the facts of the instant case.
What about their argument that the application of the doctrine is inappropriate because the transgressed title requirement directly protects the individuals who are adversely affected by these actions? So the requirement of having a duly passed resolution is meant to protect the candidates, and therefore there should be an exception to the de facto doctrine.
I don't believe that argument, Your Honor. I don't follow that argument. I can't believe that the mistakes of the party are enough to usurp and stop a Guam election. It doesn't rise to that level. This is a non-governmental entity. We can't use the mistakes of a party and a party chair to stop the Guam election. How ludicrous is that argument? To me, it doesn't seem logical.
What about if there was bad faith in the conduct of the post-election decisions?
Then,
Even though they were acting de facto, do you think that we should still recognize the de facto doctrine?
there's always an exception for fraud. I think one of the themes surrounding the application of the de facto rule in all of these other various jurisdictions that have applied it is that in the presence of fraud, abuse of discretion, abuse of power, that clearly that's an exception to the de facto rule. But here there's no allegation of fraud and no allegation of abuse of power.
But there's an allegation that there was bad faith in assuming the office because of the expired terms and the duration of which this continued. I believe that was their argument.
They're trying to make that argument, but I think the court will easily see through that argument as being unsustainable. What is the bad faith? Not knowing that your term expired? There's no allegation of fraud. There's no allegation of bad faith or abuse of discretion. You can't help if the GEC member legitimately did not know that the term expired. But even if we remove the 2 members whose de jure terms clearly expired, we still had 4 votes on November 6th. And that's really what we're talking about, is the certification of November 6th. There's no doubt in my mind that the November 6th certification was valid in all respects. The winners of the governor's race has been declared as of the November 6th certification. In the perspective of the GEC, the general election is over and the winners have already been declared.